Hey, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now see the Commonwealth of Massachusetts, court is open, please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. To my right and your left is Justice Joseph Ditkoff. To my left and your right is Justice Christopher Hodgins. We will be the panel hearing all three of the cases that are on for argument this morning. The first two matters will be heard with everyone participating here in the Hale courtroom. The third case involves one attorney who will be presenting his argument from a remote location. We will take a brief recess while our technology team sets up the hybrid equipment to allow for that participation. We will resume with that case as soon as that is completed. Those of you who have been here before know the rules. There are 15 minutes of argument time per side. If any side of the V has more than one attorney arguing, please let us know ahead of time how you'll be dividing your time, and there is no rebuttal. We're familiar with the arguments that you've made in your briefs. We are particularly familiar with the record and with the procedural history of each case. You needn't recite that. We will have questions for you. If you reach the end of your time before you reach the end of your argument, you may rest on your brief for whatever remains. If you reach the end of your argument before you reach the end of your time, you needn't continue speaking to us. With that background, let me call the first case for argument, case number 2021 P740, Chantu Cottrell versus Edward Laidley and another.
Good morning, and may it please the court. Andrew Gould for the appellant Chantu Cottrell. In granting summary judgment based on the sudden medical emergency defense, the Superior Court committed two fundamental errors, each of them reversible. First, without analysis, it assumed as a matter of law that Mr. Laidley suffered a medical emergency when genuine factual issues exist as to whether he simply fell asleep. Second, even assuming the incident to be a medical emergency, the court overlooked genuine factual issues as to each element of the sudden medical emergency defense, indeed skipping two of the elements. Both of these errors rested on the court's misapplication of the summary judgment standard. No matter which version of events the court found most plausible, and no matter which version of events the defendants prefer, the standard on summary judgment does not allow the court to weigh conflicting evidence or to make credibility determinations. Viewing all facts and inferences in the light most favorable to Mr. Cottrell, a reasonable jury could find that Mr. Laidley did not suffer a medical emergency, or that even if he did, that it did not meet the elements of the sudden medical emergency defense. This court should reverse. I'd like to begin with the first issue about whether there was a medical emergency. It's what distinguishes this case from, there aren't that many sudden medical emergency cases from Massachusetts, but even from those that we have, it's never really disputed that the driver suffered a medical emergency.
The cause of this accident was untreated sleep apnea resulting in severe sleepiness and other cognitive impairments. That's your expert.
Excuse me, Your Honor?
That's your expert I'm quoting, says the cause of this accident was untreated sleep apnea.
Right, and what was the actual cause of the accident that Dr. Krieger talks about, and this is at Appendix 338. He says that he suddenly fell asleep at the wheel. That's also what Dr. Adamczyk...
You seem to be suggesting there's some kind of strict liability for falling asleep. If it's caused by a medical condition, a sudden medical condition, then it's the same standard as if it was a heart attack.
No, I'm not. So, Your Honor, I'm not suggesting that. So I think there's two parts kind of baked into your question. So the first is whether or not you assume that this is a medical emergency. Again, as a matter of...
I'm not going to assume anything, but we're going to look at what the evidence is. And the evidence also appears to be undisputed, that it was not simply untreated, but it was also undiagnosed.
That's correct. It was undiagnosed, Chief Justice Green, because Mr. Laidley never sought medical treatment. And this goes to the foreseeability, the second part of the sudden medical emergency defense, and whether or not this was foreseeable.
I understand the evidence that you have marshaled in your brief to suggest that the fact that he didn't seek medical attention was itself culpable. The fact that he napped in the afternoons a couple of times a week, I don't know, to a layperson that suggests that the need to seek medical attention is urgent.
Chief Justice Green, what's also in the record is what Mr. Laidley told Dr. Zaslow, one of the treating physicians afterward, that for years he had been suffering from non-refreshing sleep, that he was gasping and waking up in the middle of the night.
But were there any prior occasions when he found himself, without warning, unable to continue ordinary daily activities as a result of his fatigue or exhaustion?
At least as to, I want to take it in two parts. As to driving, there's nothing in the record.
What about other activities?
Well, so for example, falling asleep in the lunchroom during work, I would say is evidence of...
He was not working in the lunchroom, was he?
Well, there's no evidence to suggest what he was or was not doing in the lunchroom.
Chief, if I may, before we get deeper, if it's okay, Chief, you are talking as if this Dr. Laszlo letter is about stuff that happened before the accident, but it's written 3 months later, and I don't see any indication that it's describing things before the accident as opposed to after the accident.
Justice Dekoff, that's not my read of it, or I read it as referring to his history beforehand. At least, if anything, then it's ambiguous in the record, at most, as to what it is referring to, which again creates a genuine factual issue. I want to be very clear. I am not here arguing that if this were to go back for a trial, that the defendants cannot raise the sudden medical emergency defense. They'll be able to do that. But at trial, where we are right now is whether or not no rational juror could find anything other than that he suffered a sudden medical emergency. And our argument is that when you view the facts and inferences in the light most favorable to us, you can do that. And if I can refer the court to one instance where the court did weigh the evidence. And this is at 380 of the appendix. It's footnote 5. This is actually going to the suddenness and avoidability, which the Superior Court didn't address, but it goes more towards this prong, in which the court is addressing what happened immediately after the incident, which is when Mr. Laidley reverses his truck, hits another car, and then moves forward. And at footnote 5, you'll see what the court says is, well, it could, and this is the word, it could have been because he was lapsing in and out of consciousness. Well, I agree. It could have been that. It also could have been that he was never unconscious, that he simply woke up from his slumber. So again, there's getting back to...
If he woke up, I mean, it does offer an explanation for how the car shifted into reverse after the impact. But that would be consistent with having the impact wake him from a sudden slumber.
It would, although there's a question, Your Honor, there as to what happened immediately before. So when exactly did he fall asleep?
What we've got to deal with is what the record shows, because that's what will be, if this case goes to trial, before the jury. And I think where the judge was concerned was that there was nothing in your proffer that suggested a triable question of evidence that you could put before the jury that would allow the jury to make a finding based on anything other than speculation.
You're correct in how you're characterizing the court's ruling, and I just respectfully disagree with that ruling that it would be pure speculation. Let's move past. Let's assume that
what we've got, let me just, to ground us, and I think Justice Ditkoff was trying to go in the same direction. When we're looking at the record, we're dealing with the medical expert opinion, right? Because other than the medical, we got a little bit from the medical records, you point out in footnote 5, but that doesn't really tell us any answers. What we've got are medical experts that offer their view of what happened.
Correct. And I think what you have there is you have dueling expert opinions, right? So their expert, Dr. Hardin, says that this was caused because he suddenly blacked out due to an unusual combination of sleep apnea and COPD. Nobody has ever diagnosed Mr. Laidley with COPD, but that's their version. Dr. Krieger, what he says is this happened, as was discussed, because of untreated sleep apnea. Now, Dr. Krieger does say, and this is at 337 and 338, that it happened because he suddenly fell asleep at the wheel. Not that he necessarily blacked out, but that he suddenly fell asleep at the wheel. But also what Dr. Krieger says is that these symptoms should have been apparent to him for years. That the symptoms of sleep apnea, they don't just suddenly emerge out of nowhere. Take Langland, for example, the case that the defendants say is on all fours from the District of Massachusetts. That case involved an undiagnosed brain tumor where it just happened out of nowhere. That's not this case. We have here from Dr. Krieger his expert testimony saying this would have been that these symptoms would have been foreseeable to him. There was a question earlier about whether we are coming forth and taking the position that Mr. Laidley is legally culpable for not seeking medical attention. As we stated in our reply brief, that's not our position. There is no legal culpability for not seeing a doctor, but there are legal consequences that can follow from that. If you are suffering from a multitude of medical symptoms and you don't seek treatment, then there could be consequences. The consequences here is when you come forward and say, I suffered a sudden medical emergency. One of the elements of that is foreseeability.
Let me just go back for a second. I don't mean to interrupt you, but I just want to go back to what I believe is kind of a central question here that everyone's trying to get at. Apart from the medical testimony that sort of forensically reconstructs what happened or attempted to, what evidence do you have in the moment, seconds before that crash? What is the evidence of negligence?
So in the seconds before the fact that Mr. Laidley, drove forward and pushed into the bus suddenly, I think that's negligence. I think if the question is instead about whether, what evidence we have that it was not sudden or avoidable, our evidence is about what happened afterward. So again, those three collective actions that Mr. Laidley took after. So putting the car in reverse, reversing, hitting a truck, moving forward, but then on top of that, what he told the officer at the time. Mr. Laidley, in his deposition, claims that he doesn't remember anything that happened. And that might very well be true, that he can no longer remember. But what is in the record is what he told the officer. And he said, I didn't mean to hit the bus. And so that could be, and so part of that could be that, again, he fell asleep. He was in control of the car, and it was avoidable. Again, this is about whether or not there are triable issues as to this. Not as to whether if the jury, for example, if the jury were to find.
Counselor, I hate to take you off of the main event, but I would like to talk about Colonial a little.
Sure.
Let's assume, giant assumption, that we find that there was enough to go forward on negligence with Laidley. Do we need to parse out the various theories of liability of Colonial, or is that enough?
So It would be, so I do think the court would have to reach it, just because there are direct negligence theories that would that would stand independently of vicarious liability.
I suspected that was the answer.
I'm sorry?
I suspected that was the answer.
But obviously, I mean, I think it is undisputed that if he was negligent in the moment, that he was working in course and scope, and that Colonial would be responsible for this. But I do think based on what we've raised, I'm sorry.
Your time's running short. We can go a little over, but so let's get into that. We've got negligent hiring, and the record is full of plenty of evidence that Colonial's hiring practices were minimalist. But I wasn't seeing the evidence that would say if they had had a more thorough vetting program that it would have discovered this problem. Am I missing it?
Sure. And our theory, Your Honor, is that had it been a more thorough, part of that would have been a medical fitness examination. Think about what he's being hired to do.
I mean, are you suggesting that you can't hire a parts driver without having them do an independent medical independent physical?
Well, I'm not necessarily saying it must be a physical, right? But any inquiry whatsoever into fitness. So they could have asked him, have you
Baseline inquiry, in order to get you over the hurdle, would have to be a baseline inquiry that there is record evidence to suggest would have disclosed this risk.
And Your Honor, if, for example, they had even simply asked him whether he had any problem sleeping, that might have raised an issue. Now, you're right that that's not in the record because they didn't ask that question.
No, but there's no evidence to suggest that that would be the expected standard of care in hiring practices.
But what our position, and I see my time is up. Our position is simply that this should have been part of the hiring process, given.
Well, that sounds to me to be a rough equivalent of standard of care.
And again,
where's the evidence to suggest that that is in fact the ordinary expectation?
So I think under this court's opinion in Foster versus Loft, where you're talking about hiring somebody fit for the duty, when we're talking about this particular job, even asking simple questions as to, have you ever felt sleepy while driving, or do you have problems with sleep?
We know he would have said no to those questions.
I disagree with that. I don't know what we would have had.
Well, you said no in response to those questions after the accident.
Well, but as to Dr. Zazzle, again, he admitted, after the incident, he admitted that he had been suffering for years of non-refreshing sleep. So we don't know.
He doesn't say that in that letter. That's one interpretation of it. He just says that after. Well, anyhow, let me just put my cards on the table here, even though we're a little over. Which is, Dr. Krieger says that because he was obese and snored, that it should have been evident to Colonial that he would have problems driving. And you can see the situation that puts us in if we find that you can't hire, they wouldn't know way to know he's snoring, but even that if you have a overweight job applicant who snores, that you can't let him drive. I mean, so I'll give you your best chance to defend how we can defer to that opinion.
Sure, and so that's, I guess, your question specifically relates to Colonial and the direct negligence
Yes,
theory.
I'm just talking about Colonial now.
Yes. So in my response to that would be that it's not simply that he's obese and had problems snoring, it was also what he was doing at the workplace, that he was seen falling asleep at the workplace, that it should have triggered somebody. I admit, Your Honor, standing here, that our evidence as to sudden medical emergency is much stronger than our direct negligence theories. We do think that we have triable issues as to direct negligence, but what I think should be clear to the court, or I would hope so, is that there are triable issues as to the sudden.
Why don't we leave it there, and we'll hear from counsel for.
Thank you for the extra time, Your Honors.
Yes.
Good morning, Chief Justice and members of the panel. My name is Bill Federico, and I represent Mr. Laidley and Colonial Automotive. It's important, I think, to just recognize the undisputed facts, which I think the panel has done. Mr. Laidley lost consciousness before the collision. The cause of that unconsciousness was an undiagnosed medical condition. There is no dispute between the experts on that issue. Even Krieger says that the cause of the accident, I think it was quoted by Justice Ditkoff, was his undiagnosed, untreated sleep apnea. So it's an undiagnosed medical condition that causes this accident. And we know that he'd never experienced anything similar to this before.
Well, do we? Because Dr. Krieger says, to a reasonable degree of medical probability, Laidley had experienced prior sudden onsets of sleepiness because sleep apnea is not an acute condition and because the symptomology was significant. To a reasonable degree of medical probability, Laidley would have felt very drowsy while driving the vehicle on the date of the subject incident. How can we disregard that opinion on summary judgment
That's Krieger
purposes?
speculating about how he may have felt that day. But
No, it's a medical opinion. I mean, you may disagree with the opinion, but it's part of the evidentiary record.
So Krieger's opinion is that he should have felt drowsy that day, but there's
Sleep
no evidence.
apnea is a different type of condition, and falling asleep at the wheel is a different type of triggering event than a heart attack or a stroke or a seizure of any type. And it seems to me that Krieger's opinion, fairly construed by a rational jury, could support the inference that this singular occasion would have been preceded by extreme fatigue that would have been recognizable to a reasonable person to suggest the foreseeability of falling asleep at the wheel.
But, Your Honor, what Krieger said was that he has an undiagnosed medical condition, the sleep apnea. He didn't know about it.
He didn't know he had apnea, but apnea is one of those conditions that would be accompanied by other physical manifestations that would be apparent to an ordinary person, right?
But there's no evidence that he had those symptoms, Your Honor.
I thought that was the portion of the Krieger opinion that we were talking about.
This is a somewhat unusual case.
Right.
You know? Oh, sorry. Often sleep apnea, as you mentioned, is preceded by years of problems, but that didn't exist here. All we know is that he fell asleep
I thought
watching
that his own assessment to the treating physician after the fact. Now, you complain that was evidence that emerged after the accident, but it was evidence that related to the period preceding the accident, right?
After the accident, after he was in a medically induced coma for weeks.
Right.
Yes, there were then sleep studies, Your Honor.
No, but he said that he had been having difficulty having restful sleep for a considerable period of time.
And he acknowledged that he was a snorer. But nothing like this, Your Honor. There was nothing to indicate that all of a sudden he would black out, which is the evidence here, Your Honor, that he blacked out. We have the witnesses who said it looked like he was having a seizure or an attack. There's no dispute that that's what caused this incident, that he suddenly blacked out. And again, he never experienced anything similar before, and there's really no reason he should expect that, okay, because I've snored, because I've taken naps, there's a chance that while I'm driving, I just may lose consciousness. That's just not the standard here, Your Honor, and the plaintiff hasn't presented any facts on the record of any sort of foreseeability. They mentioned the Langland case, but the Langland case is much different.
I don't see why a doctor couldn't look at some medical records and say, from these medical records, which are after the accident, he medically must have, before the accident, have experienced certain things. I mean, put aside sleep apnea, someone with congestive heart failure. I think a doctor could say, wait a second, he must have had heart pains before the day. No way, with this congestive. I mean, why isn't that a medical opinion that we have to, at least for summary judgment purposes, defer to?
Well, let's accept that. So he must have felt tired, is what Krieger said. Okay. Should he assume that he's going to black out? I mean, is that something he should reasonably foresee?
If he said prior onsets, it's the third time I've mispronounced that, prior onsets of sleepiness and felt very drowsy that morning?
Yeah. But if it's never happened before, why would one anticipate that while driving you're going to suddenly black out? The fact is he took naps. Okay, he took afternoon naps, and he said he felt sleepy at night when watching TV, which I'm guessing a lot of people in this room are the same. There's really just nothing in the record here other than Krieger saying he must have felt tired which I don't think is sufficient, for a jury to conclude that it was reasonably foreseeable that he'd have an immediate attack like this, respectfully. And if I could, back to Langland, plaintiff's counsel was saying, well, in Langland, the defendant was diagnosed with a brain tumor after the event. But he did have symptoms beforehand. He had problems with his gait, problems with his left leg, fine motor coordination, bladder problems. He was not feeling right. So there were a number of symptoms he had beforehand, but he didn't know he had a brain tumor.
Well, yeah, but those were I think the big difference is that sleepiness is something that is readily apparent to an ordinary layperson as an indicator of cause for concern. The kinds of precursors to the brain tumor were not of the same character of being readily understood by a layperson.
Well, I'm not sure a layperson would think that because I nap and because I fall asleep when I'm watching TV, that would mean I have severe obstructive sleep apnea, where I'm actually not getting oxygen to my brain. I don't know that a layperson would know that.
Does he need to know that? Does he need to know the particular reason why the accident's going to happen, or just that it's unsafe to drive in his current condition?
Well, I believe the standard, Your Honor, is when the operator suffers from a condition which indicates from a medical viewpoint a fairly immediate likelihood that it will result in an attack rendering him unconscious. And I'm reading from Ellen's Guide versus Silver. And frankly, I don't think the facts support that, Your Honor.
The record here is what it is. So I don't want to speculate about what a different record could look like. But on the particular day in question, isn't it likely that Dr. Krieger's opinion would explain or would describe a condition in which he would have started to feel drowsy before he suddenly fell asleep? Or that a rational jury could, without resort to speculation, draw that inference?
That's, again, speculation, Your Honor. In drowsiness does not mean that you're going to black out. I mean, I'm sure many of us have felt tired.
No, but blacking out is one of the medical experts. I mean, I think there's no question that he was asleep.
Well, he lost consciousness.
Right, he lost consciousness, and sleep is a form of unconsciousness.
That's fair, but it's a different quality.
I understand that, but we don't know exactly what happened.
No, all we have are the facts in the record, Your Honor, and the witnesses said he looked like he'd blacked out, that he'd had a seizure or an attack. The medical records suggest that he was in and out of consciousness. He couldn't get air to his brain. They found that he had elevated levels of carbon dioxide and low levels of oxygen in his brain. That's not what you get when you just fall asleep. You're actually preventing air from getting to your brain. So he didn't have oxygen in his blood, Your Honor. It's a little different than falling asleep, respectfully.
What about the putting of the car in gear after the crash and moving it? What do we make of that?
Yeah, it's hard to explain what happened. Obviously, nobody quite knows. But it doesn't tell us anything about what happened before. We know he rear-ended the MBTA bus, and he was unconscious. At some point, he must have regained consciousness briefly and then lost it again. But I don't think that tells us anything about whether this was foreseeable.
What about as far as causation? Doesn't it speak to anything as far as that?
Well, again, we know he blacked out, and he appeared to black out again. Now, why he's not getting oxygen, I'm not a medical expert, but the explanation is it's a combination of, as Dr. Hardin would say, combination of the severe obstructive sleep apnea and the COPD, which was undiagnosed.
Isn't this a little like the Carroll case, where the heart attack occurs while the person's driving, but he may have run the light before he had the heart attack?
Yeah, and I believe the difference in that case is there was a genuine factual issue of when the heart attack occurred. Here, all three experts say that the accident was caused by a loss of consciousness. Nobody is saying he suffered the loss of consciousness because he hit the bus. So I think that's what makes Carroll different.
The crucial question of fact in this case is whether the loss of consciousness was foreseeable.
Correct. On the facts we have here, Your Honor, it was not. If a person just because they're overweight and has high blood pressure and naps in the afternoon or falls asleep at night, if that makes it reasonably foreseeable that you're going to black out in a car accident, there's a lot of people who shouldn't be on the road, and I don't think there's any law to support.
I drove up this morning up the Southeast Expressway, and it seemed to me there were quite a number of people who shouldn't be on the road, but that's a different story.
That may be, Your Honor. If I could just touch on the colonial issue.
Oh, yes, please do.
Obviously, if Mr. Laidley was not negligent, none of the claims against Colonial survive. There's no vicarious liability if their employee didn't commit a tort. There's no negligent entrustment case if there was no tort. Let's assume for a moment that he was negligent. The negligent entrustment case, I think, fails because there just is no evidence that they could have discovered this. Even if they'd done a more rigorous questioning or done more due diligence, what would they have discovered? Nothing. This was undiagnosed. It was untreated. This isn't a DOT driver where they have to go through a physical and et cetera. He wasn't driving an 18-wheeler. He was a parts delivery person. Like many jobs, it required him to drive a car, and employers aren't required to have them submit to a physical examination or go to an extra doctor or anything like that. So there was nothing that would have been discovered had they been more rigorous in their employment practices. Unless there are any other questions.
Seeing none?
Thank you.
Thank you both.
Thank you very much.
Next case on our list is case number 2022 P902, Arthur A. Boyle versus Cheryl A. Boyle. And just as a reminder, we will be taking a very brief recess following the argument in this case to allow setup of the hybrid equipment.
Good morning, Chief Justice Green, Justice Dickoff, Justice Hodgins. May it please the court. Patrick Dolan for Arthur Boyle. I am going to try and streamline the argument here to make a couple of really simple points. The first is that there was no clear and unequivocal command in the separation agreement that was at issue in the trial that took place in the probate court. The second is that there was no clear and undoubted disobedience of that command. And because the judge found otherwise, the judge erred as a matter of law. To orient things a bit, in 2002, Arthur Boyle, who was a decorated Lowell police officer, retired under what is often termed as the Hart Bill, a accidental disability retirement. In 2005, in December 2005, he and his former wife, Cheryl Boyle, executed a separation agreement, which in May of 2006 was incorporated into a judgment. The separation agreement contains a provision which states, the parties to this agreement each agree that wife will be entitled to 20% of the husband's pension while husband is alive. That's the key words in this case. After the divorce, Cheryl Boyle did not...
Stop you right there. There's no serious question, is there, that when the parties entered into the provision that you've just quoted, that by reference to the pension, they meant the husband's disability retirement benefits?
I don't think there can be, Your Honor. I think an effort was made in the brief. I did not either represent Mr. Boyle at trial, nor did I draft his brief. There's an argument that's attempted to be teased out.
I just wanted to be clear that we're only dealing with arguments that are plausible here.
I hope so, Your Honor. The language in that clause, and I'm either going to sound pedantic or foolish, is grammatically interesting. It says, effectively, wife is entitled to 20% of the pension. She will be. So there's a future element to it. Is entitled is a transitive verb. It connects wife and something else. That something else is 20% of the pension. None of that is directed to Mr. Boyle. In order for that language to constitute a command to Mr. Boyle, you have to read into it meaning that's not there. The language in that clause provides Mrs. Boyle with a right that she is free to seek to enforce or not seek to enforce. For 20 years, she didn't seek to enforce it.
So are you conceding that he was at least in contempt once she asked for the money and he didn't give it over to her? That'll change the judgment quite a bit, but...
Correct. I think that as of when she asked for it, I think he likely had an obligation to cooperate in her efforts to get it, but she wasn't limiting her efforts to the future. She was claiming she had the right all the way back to 2020, but I think certainly as of 2020, when she made the demand for it, he had an obligation to cooperate. Yes, Your Honor. If we look at that language, wife will be entitled to, and instead of will be entitled to, we say need. Need is a transitive verb as well. Wife needs 20% of the pension. Again, doesn't implicate Mr. Boyle. Wife has 20% of the pension. Doesn't implicate Mr. Boyle.
Well, except that he is the person who will be the recipient of all of those proceeds, and there is no mechanism for her to receive them unless and until he pays them over to her after receipt.
But that's not what the language says. The language says not that she's entitled to 20% of the proceeds of his pension. It says she's entitled to 20% of the pension. That's different because that would require what actually happened here, which is a domestic relations order that then goes to the pension system, and they segregate 20% of the pension before it's sent to Mr. Boyle. So to the extent it implicates him, I would argue, into an obligation to cooperate, not an obligation to implicate. If this said, for example...
No, but she can't initiate the preparation of the quadro.
She absolutely could have gone to the probate court and requested a domestic relations order.
She could have gone to Mr. Boyle and requested that, and his attorney would have been able to prepare that and then file it, right?
She could have done that, but she didn't, correct. Absolutely. I don't believe, Your Honors, that there was any evidence that Mr. Boyle could have, for example, walked into the Lowell retirement office and asked that they segregate the 20% or assign it to his former wife. I believe that the only evidence as to how it could be done is actually what happened, which is the domestic relations order. If this clause said, for example, a wife will be entitled to use the family vacation home for 10 days, no one would interpret that to obligate Mr. Boyle to make sure she uses it for 10 days. But because it involves money, there seems to be, or there was at the trial court level, an approach that it means an obligation because it involves money. But that's not what it says. It gives her a right. It doesn't give him an obligation. So if we can't say what the obligation is, it could be, as Your Honor says, give her 20% of your check. It could be, go to the retirement board or your attorney and get a domestic relations order. If we don't know what he's supposed to do, how can there be a clear and undoubted disobedience of a clear and unequivocal command?
This is a much better argument than was in the brief.
Quite different.
But I wonder whether it's a little too clever, because I think you're convincing me that he had many different ways of complying with this, how it was written. Could get the qualified order, could pay her the 20%, could even stick the 20% in a separate account for whenever she wants it. But why is one of his options to do nothing and keep it until she speaks up?
because that's what the language says. It says she will be entitled to. So there's a future element to this.
Well, let me amend that question. Because he didn't just keep it until she spoke up. He kept it after she spoke up.
He kept after, which I believe raises the prior issue of, is he in contempt when she asked for it in December of 2020? And I think that's a problem for Mr. Boyle, absolutely. But why he could do nothing, I think, Your Honor, is the future element. She will be entitled to it. And also, to use my analogy, she has to exercise it. It's her right. Litigants often have a right to a jury trial. They don't have to exercise it.
I thought the argument in the trial court was that the reason he didn't give her the 20% is because they kind of struck a side deal outside of court, that she could keep one of the houses, and he could keep his pension. Wasn't that what was going on in the trial court?
I don't believe, at least that's not consistent with my reading of the trial transcript, Your Honor. I believe what the evidence was that was argued on behalf of Mr. Boyle was he didn't believe this provision related to the pension he was receiving. He thought it related to when he passed away. And just to give some numbers on that, so in order to get his accidental disability retirement knocked down from 100% to provide for survivorship benefits, he takes a 20% haircut.
15%.
15%, excuse me. In order to get that, so he takes a 15% haircut, and then he would have to take an additional 20% haircut to provide her with this 20% per term, if you will, although it's not specified, but at some point, 20%. The testimony at trial, I believe, Your Honor, and I've only read the record, just as Your Honor has, was that he simply didn't believe he was required to pay her. And
Let me go back for just a second to understand. If let's assume for the moment that we accept your premise that he was only in contempt from and after the time when she made a demand for the proceeds and he refused. That would not negate her entitlement to the 20% that preceded the demand. It would simply vitiate the finding of contempt, right?
I struggle with that, Your Honor.
Imagine why.
But I think, to go back to my earlier note, that the language doesn't say proceeds from the pension, it says pension. Which
yeah,
is,
but what is the pension divorced from its value? And what is its value divorced from the proceeds during the interim period?
But its value divorced from the past is different.
Oh, I understand that, but the agreement was in place during that period of the past. And I guess what I'm trying to understand is if we have a contempt that covers some portion, all of the other consequences, the collateral consequences, attorney's fees, et cetera, the finding of contempt would survive, and the contempt itself doesn't bear on the measure of damages, right?
Correct.
So if you are successful in persuading us by your argument that the contempt only began upon the demand, what does it change?
I would argue, Your Honor, and again, here I'm risking being a pedant or a fool, pension is an objective value at the time of the request. So she will be entitled to pension. If money has gone from that pension and been distributed to Mr. Boyle, it changes what pension is when she requests it. So she's requesting...
She'll be entitled to the pension after she requested it. I mean, I understand your argument about the obligation, but her entitlement arises upon execution of the separation agreement, doesn't it?
That's the interesting thing. It says she will be. So she's entitled to... She
will be. I mean, I don't know.
I don't want to stake my claim on will be
here, but I think once the parties affix their signatures to the agreement, we would ordinarily understand the provisions of the agreement to become effective, right?
Absolutely, Your Honor. Yes. yes. But I do think that the decision to delay, and the parties had different reasons why there was a delay. I do think the delay impacts the value of the right.
Well, I still want to focus on this. I want to understand why Mr. Boyle didn't pay. And on the record, on page 47 of the record, he's asked that. Why didn't you pay your pension? Why didn't you pay 20%? And he said, because I had given the house to Cheryl and I had my 10% pension, the disability pension, and that's all I wanted. So it's clear in his mind that whatever the court had ordered really didn't matter because they had reached some other arrangement. Isn't that correct?
And that's a misreading of the agreement, Your Honor, absolutely. In his mind, he believed, I've given up the house, we're waiving alimony, I get to keep my pension. That was effectively his testimony.
Is it more than just a misreading? It seems like there was not a meeting of the minds here as far as what took place.
I think there was no meeting of the minds at the time it entered into, but I think that Mr. Boyle is sort of stuck with the language, and I think
You can't argue that he can subjectively ignore the objectively clear purpose and statement of the agreement.
I think there was an effort to make that argument, but I'm not.
Right. Thank you.
Thank you, Your Honors.
Good morning, Chief Justice Green, Justice Ditkoff, and Justice Hodgins. I am Cheryl Garrity, and I'm here on behalf of the appellee, Cheryl Boyle, who is
Garrity, before we get too far into this, to be clear, I looked in the record appendix and didn't see a notice of cross appeal on your client's part. You've made some arguments that the judgment was incorrect and in a manner adverse to your client, but without a cross appeal, I don't see how those issues are before us.
That's true, Your Honor. We did not enter a cross appeal.
I want to make sure that my understanding of the state of the record was correct. So let's confine our conversation then to the question of the husband's contempt and the argument that he's making here that the contempt would attach, if at all, only to that portion after the wife made demand.
Sure. Basically, the contempt judgment is upholding a surviving separation agreement regarding property division of the parties at the time of the divorce. If you believe the argument that it should only have been 20% from the date that Ms. Boyle filed her complaint for contempt, you're ignoring the findings of the trial judge where he found that Ms. Boyle had approached Mr. Boyle a number of times to no avail, looking for the 20%. You also would ignore the fact that in 2014, when Ms. Boyle approached Mr. Boyle for her share of the pension, he gave her a check for $10,000, which was roughly 20% of his $54,000 pension for 2014. And in fact, his second wife testified at trial that, quote, there was no need for him to give her another $10,000. Their divorce was done. It was over, except if Mr. Boyle at the time knew that he was supposed to be giving Ms. Boyle the 20%. The language of the separation agreement is interpreted according to contract principles, and it requires that we look at it and give it its plain meaning. There is no secondary meaning to the language. The language, if you start earlier in that sentence, says, "The parties each agree." So Mr. Boyle agreed that Ms. Boyle will be entitled to 20% of the husband's pension while husband is alive, as provided by the Lowell retirement system.
But why did she wait 14 or 15 years to ask for the money, if it was so
Well,
clear?
Originally, she waited 8 years, and he gave her the $10,000 8 years later. Ms. Boyle was under the mistaken impression, remember, she was pro se at the time of the divorce, and relying upon Mr. Boyle and his counsel, she was under the mistaken impression that she had to wait until she reached retirement age, and that she believed that the Lowell retirement system was putting 20% aside for her for when she reached retirement age. Mr. Boyle retired at age 50, 3 years before the divorce agreement. In the ordinary course, if both parties are still employed and have not started collecting their pension, then the pension fund does make provisions to set aside the alternate payee's share of the pension for when the parties reach retirement age. In this case, Ms. Boyle is a little bit older than Mr. Boyle, and so she thought she had to wait.
Right. So at the time the judge entered this order, would it be fair to say that both parties had a different understanding as to what that order meant?
Absolutely not. Mr.
Why?
Boyle, well, first of all, the agreement would not have been fair and reasonable then. This pension is the largest asset that the parties had at the time of the divorce. The other properties, the real estate, the bank accounts, those were divided 65-35 in favor of Ms. Boyle. It did not include the fact that she had $28,000 in debt and Mr. Boyle had no debt at the time of the divorce. So by giving Mr. Boyle a pension that's now paid out over $800,000, far more than the assets of both parties at the time of the divorce, it would not have been judicially sanctioned as fair and reasonable.
Yeah, but at the time that the judge entered this order, we have one party, the husband, views it as, well, this doesn't matter because I'm giving her the house and we're going to be all square after that. And then we have the other party, the wife, viewing it as, well, I don't get to collect any of that until I retire. So they're both wrong.
Well,
So
except
how is there a meeting of the minds here?
Oh, excuse me. Except Mr. Boyle states that that agreement, you get the house for me getting the pension, was made at the time they signed the retirement option form and selected option C. And that was 3 years prior. He claims it's an oral agreement. I think he's trying to create an ambiguity. And if you look at the full separation agreement, it states that on paragraph 7 of that agreement, the husband and wife agree that there have not been made and that they have not relied upon any promises, warranties, or representations except as expressly contained herein. So some oral agreement made 3 years prior is not effective in terms of creating an ambiguity as to what this language meant.
Counselor, I think the problem here is the husband now says, well, when Ms. Boyle contacted me, then I had to cooperate with getting the pension, and I didn't do anything before that. And Mrs. Boyle's opinion was that she didn't have to get any money until he actually retired, not just from the police job, but from the security job he was doing later. So everyone seemed to think that he hadn't violated the order until some point later than when this money starts being owed according to the judgment.
Well, certainly, that would at least go back to 2014 when he gave her the $10,000.
Sure.
But the court findings of fact are that Ms. Boyle had approached him numerous times. Also, Ms. Boyle wasn't under the impression that Mr. Boyle had to retire from his security position. She was under the impression that she had to retire.
Right, you're right, she had
And
to.
she was fully employed and was not collecting any kind of pension benefit.
It's just hard to find, I understand your point that it's certainly before 2020, but it's hard to find clear, disobedience of a clear command when both parties thought, at least for some of the time, that there hadn't been any violation of the agreement. How do we get around that?
Well, Mr. Boyle, every single month, was pocketing 100% of his monthly pension benefit. He knew that the future tense of this said that he agreed Ms. Boyle would be entitled to 20% of each of those future pension benefits that he was pocketing.
Sure, but if when she finally contacted him, he had said, oh, sure, here's the money, here's a check for it, would there be any contempt?
I believe there would be a contempt, Your Honor, because she's been deprived of her marital assets for all those years, and I think it would not be fair and reasonable for somebody to skirt a written contract where they agreed to give somebody else a share of assets just by simply saying, I'll wait until they come after me. Maybe I'll get away with it. I don't think that would be a fair and reasonable interpretation.
That's not what he said. And it's also not what the agreement said. The agreement did not, as a husband's counsel has observed here, the agreement does not impose on him an obligation to pay that money in any particular manner. So, it's an interesting question. What would have happened had he acknowledged her entitlement when she asked for the money and everything had gone forward from there? That's not what we have here.
Sure, but except the parties to a separation agreement owe a fiduciary duty to each other to work in good faith. There is case law to that effect. I don't have it at my hands, but they do owe a fiduciary duty to each other to carry out the terms of a separation agreement that they both entered into in good faith.
Well, yeah, but in circumstances where both of them labor under a good faith mistaken understanding of what it requires, it's hard to assign bad faith to either of them for the conditions that obtained before they sorted things out.
Ms. Boyle isn't under a mistaken impression of what the terms of the agreement state. She was mistaken as to the process by which she would collect the monies owed to her. Mr. Boyle is now trying to create an ambiguity within the agreement in order to not pay Ms. Boyle her share of that marital asset.
Did the judge have another option here? Because you had referenced this, we're talking about marital property here. So wouldn't the judge be able to look at this and under Chapter 208, Section 34, the equitable division of property, couldn't the judge go back and look at this and take into account not just the language of that order, but also the course of dealing of the parties here over a 15-year period and come up with an equitable solution here instead of attempting to enforce 14 years later the language of this particular order? Couldn't the judge have done that as well?
I don't agree with that. This is a surviving separation agreement, and therefore the property division provisions are not susceptible to modification. And so he could not go back and do that. At the time of the divorce, a judge could have looked at the terms of this and found it was not fair and reasonable and not have approved it. Once it was approved and became a judgment of this court and judicially sanctioned at the time of the divorce, it's a judgment and it's a contract, and therefore it's enforceable. There is no statute of limitations for Ms. Boyle to come forward and try to enforce that agreement. It doesn't change the terms of the agreement. She was entitled to that 20% of the pension from the date they signed it, December 20th, 2005, and every month going forward. She may have been mistaken that the money was being set aside for her, but that doesn't mean that she thought that the money was being collected by Mr. Boyle and spent and enjoyed by Mr. Boyle for all those years. The only other thing that I would point out is that Mr. Boyle at trial was still testifying that he didn't owe her anything, and that 20% referred to the difference between option A and option C. But as Your Honor has pointed out, the actual difference based on the facts of the case indicate that the difference is 15%.
Well, I have a calculator in my desk.
That doesn't appear to be the argument on appeal.
Yes.
Can I
So
ask you
I
just
would ask that it be upheld.
One technical question. I didn't really understand your request for attorney's fees. I just didn't understand which basis it was. Could you just tell me what the basis is for that?
At the time of trial?
No,
or
now, for appellate attorney's fees.
Sure. I think that Mr. Boyle has made a frivolous appeal, looking at his brief, and that he's raised equitable principles that don't apply because there is a legal remedy, and that as such, Ms. Boyle should be entitled to the additional legal fees she's incurred, still trying to enforce the original
If we don't consider the
divorce.
appeal frivolous, do you have an independent basis or an alternative basis in support of your request for fees or not?
Well, just the fact that it's an appeal of a contempt judgment, and that parties to a contempt judgment, the statute does provide that the court may award
So
the
unless we set
reasonable
aside the
attorney's fees.
contempt, you would say that the contempt itself is an adequate basis for appellate attorney's fees, even if we don't conclude that it was frivolous.
Correct.
All right. Anything further?
I do not have anything further.
Thank you. Thank you
Thank
both.
you.
We will take a brief recess while we prepare for the third and final case on our hearing list this morning.
All rise.